What's up, everybody? I'm Coach Joe Devosevic. Don't forget to subscribe to my channel. Well, did you subscribe yet? What are you waiting for?
This is the trust concept slide. I'm going to draw this out real fast. So you've got Genesis chapter 1 and verse 1 up at the top, where God gave us his Bible, and his Bible kicks off by saying, in the beginning, God created the heavens and the earth. And then he goes on, which is God's way of saying, I'm in charge, I created everything, I can do whatever I want because I'm the boss, I'm the king, I'm the God, I'm everything. Then you've got the Bible, and it goes to the death, the burial, the resurrection of Jesus Christ. This is the only way into salvation. That is the DBR that I have, the DBR mean, that the death, the burial, the resurrection. When Jesus rose from the grave, he said to his disciples, all authority in heaven and earth is given to me. And then he says, go. That go is a commission. That's a grant of authority. When Jesus granted authority to his disciples, the Christian church, right, the Church of Christ throughout history have been the people who have changed the world, who God works through. That's who Jesus chooses to work through. Our founders were Christians. Because they were Christians, they understood the Bible was the Word of God, and they saw it not just as an instruction book, but they saw it as God's wisdom for how all of creation is ordered. So then the people, down left, reserved, which means they reserved their rights to themselves. These rights include life, they include liberty, they include property, they include due process, which I will label on this piece of paper as DP. Then they created a big wall. On the left, you've got private. On the right, you've got public. These are different jurisdictions. Your rights come from Jesus, come from God. Those rights are in the private. Everything in the government is in the public. So if you look down right, they created government. How did they create government? They wrote it down on a piece of paper called the Constitution. The Constitutions are express trusts. Express trusts are written, there's the express, and trust, it's an entity that holds property. The property that the Constitution holds is power that's granted by the people. So the people grant all the power inside of the document. Just like Jesus, whenever he came from the grave, he says, all power is given to me, right? The power was granted to Jesus. And here, in like fashion, not salvation, but in like fashion, the people granted all political power, the people granted all the power that government has to government, and they did it in a piece of paper called a constitution. That constitution then created a legislative branch, an executive branch, and a judicial branch. These three branches of government make up the frame of government. And if the people, you see that arched arrow, if the people ever want to change the government or ever want to do things, what they must do is send notice and affidavit of their rights and clarify where in the law the government is trespassing their rights. And if you do that, you will get your remedy.
Hello and welcome, everybody. I'd like to discuss a little bit more of the law with you so you understand. Today, our topic is statutes. What is a statute? And I'm hoping that the video clip just prior to this gave you a little bit better idea of how power is distributed. It's created, distributed from the people through the government. And this gives you an idea of the relationship that we don't often understand between us as the grantors through a constitution to the government, who are our trustees. I'm going to put something up on the screen here. Share it. Let's read a little bit about what a statute entails. A statute, an act of the legislature declaring, commanding, or prohibiting something, a particular law enacted and established by the will of the legislative department of government. This word is used to designate the written law. This is the written law. This is a statute created by the legislature, which is contradistinction, which is different than what we know as the common law. The common law is our Constitution. It's the general law. Now, if we look at how we define common law, and both of these definitions are coming from the Law Dictionary, Black's Law, 4th edition. So we're giving you legitimate definitions of what attorneys use to describe these terms. The common law, as distinguished from the Roman law, the modern civil law, the canon law, and other systems. The common law is that body of law and juristic theory, which was originated, developed, and formulated and is administered in England, and has also been obtained through Anglo-Saxon stock, obtained among most of the states and people. Common law, right down here, as distinguished from law created by the enactment of legislatures. This legislature is a branch that we created, legislative, executive, and judicial branches through the Constitution. The legislature, the laws that they create are called statutes. So these statutes are what we are going to cover today. So now when it says as distinguished from law created by the enactment of legislature, tells you that we have the common law, which is the Constitution, versus a statute, which is created by the legislature. Attorneys will give you a different definition of what common law is. They'll say that it's judge-made law and it progresses and it evolves through time. The law, the true law, the Constitution never evolves. It's set in stone. Your rights are set in stone. So next we will share here a few terms, and we'll go through this pretty quick, and I'll break it down so that we can understand. When we are looking at a statute, we first have to understand a couple different terms. So when we're looking at a statute, there's two kinds of law. There's the general law, which applies to the people and is a private issue. It's of private capacity. In the general law, which is different from a special law that attorneys use for public matters. The general law is of judicial essence, which involves the Constitution, our Declaration or Bills of Rights, depending on what state constitution you use, and it moves by the common law, which is what we described by definition earlier. Examples of general law. An example is your right to bear arms. We have a right through our Declaration of Rights in Pennsylvania to bear arms. We also have a right to a trial by jury. A trial by jury and a process called due process. And in this constitutional due process, you are swearing, it's a sworn testimony against someone else's claim under their sworn testimony. That is a real judicial setting where you swear and someone else that's claiming something otherwise is swearing either against you or defending theirself. One sworn affidavit against another sworn affidavit, which is very simple, which attorneys make complicated. We're owed due process is one of our rights in the Constitution. And inside of that due process, we are looking at the facts of the case, not anything other than facts, what I swore and what you swore, which made our court case. If we look on the other side at the special laws, this is an administrative setting. It's an administrative process, which is different than the judicial process. And inside of an administrative process, which attorneys use, are statutes, codes, rules, ordinances. And examples of these are a carry permit, which is counter to your right to bear arms. So a carry permit is statutory. Tax court is another administrative tribunal. Family court, jury trial, which is different than a trial by jury. So attorneys use criminal and civil rules of procedure when they go into court. They also argue one statute against an attorney's other statute. So when you hire an attorney, pay close attention to what they're arguing in court. It's one statute against another statute. It's not arguing your rights. Only you can argue your rights and stand up upon your rights. Another thing, attorneys never swear. So they're not swearing to the statute that they're applying to you or defending you with. They never swear. In a real judicial setting, one sworn testimony against another sworn testimony makes it a valid, legitimate court. Therefore, if an attorney is not swearing under penalty of perjury, it becomes hearsay evidence. It's hearsay. It's not sworn. It's not a sworn affidavit. Just a little, that's probably $1 million of information I just gave away to you folks today for free. So we're going to scroll down here and we're going to look at understanding the statute and who creates the statute. The legislature creates the statutes, going back to this, which is called special law. These statutes are for the government to control the government. They aren't created to go against your rights. Your rights are reserved, they're saved, they're locked down, they're inviolate. We just don't understand how to express our rights because we've never been taught the Constitution. So the government can have all the control at once over other government entities and employees, and they use these statutes, they should, to handle the people's affairs. And that's what a statute is created for, to handle your affairs, not to go against you. Next, the people created the legislature. So if we created the legislature, how can the legislature create anything to go against its master, the sovereign one? The government has contracted with the Constitution. They swore to it. Therefore, make them accountable to what they swore to. Your rights are greater than statutes, stronger than a statute. If you argue your rights, they can't go against your rights with a statute. Right here, the only way to express your rights and bring them to fruition is by standing on them through notice and affidavit. So sending love letters to your government, if they're ever going against your rights, you can send them notice, an affidavit, a sworn affidavit under penalty of perjury, challenging the government to what they swore an oath to. And we'll go over an example of that in a second. Notice and affidavit are evidence for the court. Whoever showed you how to write a notice or an affidavit? I will refer you to my law teacher, Dave Jose, who teaches people how to create notices and affidavits. I can also show you simple samples of that. But this notice and affidavit holds true as evidence in court. So if you send them a notice and they can't respond to it because they swore an oath to it, that becomes a court document that you can fold up, store, and then whenever the issue arises, you can take that into court with you. Here's an example of how you can use your rights against the statute with a notice and an affidavit. An attorney who works for the IRS says that you have violated a Title 26 tax code. Therefore, we need you to open your books. You respond to that notice that was given to you with a few simple questions. Do the people have the inherent right of enjoying and defending life and liberty, of acquiring, possessing, and protecting property? in Article 1, Section 1 of the Pennsylvania Constitution. The next question you ask is, do the people have a right to a trial by jury and security from searches and seizures and due process of law, which is Article 1, Section 6, 8, and 9 in the Pennsylvania Constitution. And upon sending this notice, if they respond to the notice, they're stuck. If they don't respond to your notice, they're also stuck because they swore to everything you're asking them in the Constitution. Searching and seizing your property, you're also owed due process of law, so they have to give you that in a court of record with a trial by jury. So you have just responded using your constitutional rights, which are above the statute which Title 26 is providing through the tax code that's going against all of your rights in the Constitution. So therefore, you have documentation and evidence. Go back and replay this information that I've just shared with you so that you understand the rights you have in the Constitution. They're the highest law of the land, and this makes you a monster in the law.